Legal Services of the Hudson Valley has graciously asked me, Cecilia Morris, as the Chief Judge of the Southern District of New York Bankruptcy Court, to introduce this video. Thank you for taking the time to learn about helping individuals overwhelmed with debt to obtain a fresh start. Bankruptcy is one of the greatest benefits that we as citizens of the United States have. In most other countries around the world, insolvency laws do not exist for individuals. Debt is an important part of our nation's economy. Things are routinely purchased on credit, including food, and when a sickness or a loss of job occurs, debt can easily become overwhelming and unmanageable. When this happens, it is difficult to even buy the bare necessities, including food. It's almost impossible to get or maintain a car, which makes it difficult to go to work, a catch-22 for the average person who studies have shown are only 2 paychecks away from needing, and that's why this program is important, to file for bankruptcy. Carrying high levels of debt also causes deep stress. Another study that was done by 2 professors, one from Harvard and one from Princeton, show that filing for bankruptcy is as emotionally difficult as losing a child or going through a divorce. The good news from that same study is getting a discharge promotes greater financial satisfaction and, interestingly enough, a longer life. Bankruptcy is a wonderful tool that can be used to bring financial stability and vitality to an individual, thus the entire family unit. And your help for these individuals is important. To prepare for bankruptcy filing, the client needs to get a lot of financial paperwork together. Legal Services will help your clients gather the necessary items. Most every individual debtor who wants to file for Chapter 7 has to participate in a session with an approved credit counselor before the case is filed. Actually, it's 2 sessions, and Legal Services will again guide you through this. After the case is filed, you and your client will be expected to attend what's called the meeting of creditors. During the meeting of creditors, the bankruptcy trustee will ask various questions of the debtor's financial situation. You've gathered the documents, you know the information, the debtor will have to testify to it. Once this is all done properly, the court will grant a discharge of the debts. The discharge prevents creditors from attempting to collect any debts against them personally that arose prior to the filing of the bankruptcy. Thus, for all intents and purposes, the discharge effectively wipes out consumer debts. However, it is important to note that not all debts are dischargeable, including certain taxes and child or spousal support obligation and secured debts. Please be aware that some creditors may attempt to collect discharged debts. Please let your clients know and emphasize to them that if someone attempts to collect a debt, they need to call you or Legal Services. They are free from debt collection efforts. I'm proud of our chosen profession. It is a profession that tries to solve problems for clients. Heavy debt load takes a toll on individuals and families. Through your work, you can help resolve their financial problems. Don't be intimidated. Legal Services will help you through this process. Helping an individual will also be fulfilling to you as a lawyer. And remember, it is a legal process that results in a happy ending, the discharge of the debts. If you have any more questions, there is some additional resources for you, including Legal Services and the United States Court's website at www.uscourts.gov. That's USCOURTS. Thank you for participating in this, and thank you for helping these individuals in this life-changing process.
Hi, I'm Jonathan Petz. I'm a bankruptcy legal services lawyer in New York, and I'm going to give you a sense of how the Chapter 7 bankruptcy process works and why it's a really attractive pro bono opportunity. So, Chapter 7 bankruptcy does two really important things for low-income legal services clients. First of all, it erases unsecured debt. So, it erases credit card debt, medical bills, past civil judgments in most cases, and it usually won't help with student loan debts, child support, debts from fraud, and there's a number of other exceptions, but those exceptions are generally few and far between. So, erases debt. The second thing is, if you aren't a homeowner, if you don't have high value property, Chapter 7 will usually let you keep all the property that you have. So it's this great bargain, discharge debt, keep property, and it's designed to give debtors a fresh start, to move on with their lives and to become successful economic members of society. So the bankruptcy process is really 3 steps. So you have one, you file a petition, and you have to take a budgeting course before you do that. Second, you go to a 341 meeting where you're going to be interviewed by a trustee to make sure that no assets are being hidden, and that usually takes under 5 minutes. And then third, you take another budgeting course, and you receive a letter in the mail a couple months later saying that all of your unsecured debts have been discharged. It's a really, really powerful moment for legal services clients, and it's really exciting for them to move on to the next steps of their lives. Now, the first question to ask when you're meeting with a client is, would this client benefit from filing for Chapter 7 bankruptcy? And there's a couple of different issues to think about when you make that determination. The first issue is, how much debt does this client have? So if a client has under $5,000 in debt, bankruptcy is almost always a bad idea. It's just not worth it. There's effect on credit. There is the limitation that you can only file once, or you can only get a discharge once in an 8-year period, and just usually a bad idea. Second, if you have over $5,000 in debt, but under $10,000 in debt, bankruptcy, again, it's probably not a good idea. There might be some mitigating circumstances, which we'll discuss later, but that's sort of the middle ground. And then once you get over $10,000 in debt, then in dischargeable debt, then bankruptcy becomes a much more attractive option. Another metric to think about is, how much dischargeable debt do you have? And that's, again, credit cards, medical bills, civil judgments, not student loans, child support. How much dischargeable debt do you have in relation to the income that you're making? So to be a legal services client, you have to be making well below the median income. And so let's say you make $20,000 a year. If your dischargeable debt is over half of your annual income, then Chapter 7 can be a very good option. So I make $20,000 a year, I have $30,000 in debt, then Chapter 7 might make a lot of sense. Now let's think about, if you don't have a lot of debt, if you have under $10,000 in debt, what are the reasons that you might want to file? Well, if your wages are being garnished and that's reducing your income each month, then Chapter 7 might make sense. Also, if you're dealing with eviction, Chapter 7 can be a temporary, not a permanent stopgap for that. And then also, it's important to think about your credit. If you file for Chapter 7 bankruptcy, that's going to stay on your credit for 7 to 10 years. But a lot of clients who might be wanting to file for Chapter 7 have such low credit that bankruptcy will actually improve their credit in the short term, particularly if your credit is in the 500s. And so if you can't get if you're being turned down from jobs, if you can't even get a secured credit card, then your credit might be so poor that filing for bankruptcy with under $10,000 in debt might make sense. The next issue to think about when you're deciding, would I benefit from filing for bankruptcy, is will I get to keep all of my property or am I going to lose some of it? So about 96% of Chapter 7 cases are no asset cases, meaning that the debtor gets to keep all the property they have, in which case filing is a very attractive option. The big exceptions to that are if you own real estate. So if you own real estate, then there is an exemption around $150,000 currently in New York for a single filer. If you have more equity than that, if the property is worth more than that, then you're probably going to lose your home. It's going to be sold by the trustee, and Chapter 7 is not going to be a good option. The other category of cases are tax returns. So if you're expecting to receive a significant tax return in the next few months, then that can be taken by the trustee, and so waiting to file would probably make more sense. Other categories where you might have property that could be taken by the trustee, if you have a personal injury claim, you got hit in a sort of slip and fall, and you are suing somebody, and you're expecting a return from that. Chapter 7, it doesn't make sense to file now in many cases because you're going to lose that recovery to the trustee, and you might be able to keep it if you delayed filing until later. Lastly, if you are going to receive any sort of life insurance or inheritance in the next 6 months, Chapter 7 probably doesn't make sense to file now. Recent taxes are not dischargeable, but 3 years or older, those taxes in many cases can be dischargeable. So if you have a really big tax bill from 2 years ago, it might not make sense to file for Chapter 7 now, even if you have enough debt, because if you wait another year, that big debt could be discharged. Another thing to think about are big expenses that you're expecting in the near future. Let's say you are going to have an expensive medical operation and you don't have health insurance. You definitely don't want to file for Chapter 7 now, because if you incur that medical expense a month after you file, you're going to be stuck with that, and you can only get a discharge once in every 8-year period, so that's not a good option. Other reasons to delay filing. If you've used a credit card to buy luxury expenses in the last 90 days of significant value, that's not going to be discharged in a Chapter 7 case, and so that's a reason to delay filing right now. Another one that comes up a lot is recent transfers to family members. So let's say I owed my brother $5,000, and let's say I paid him $3,000 last month. If I file for bankruptcy tomorrow, the Chapter 7 trustee is going to be able to go after my brother and recover those funds and distribute them to creditors equally. And so it might make sense to wait a year from that transfer so that you don't have any fraudulent transfer that the trustee can go after your brother for. Another issue that comes up a lot, as we said, is previous bankruptcy filings. So if I filed for Chapter 7 5 years ago and I got a discharge, I can't file now because I can only get one discharge in every 8-year period. And so that would be a reason to delay filing. And then the final issue, which comes up a lot with legal services clients, is the client judgment proof? So let's say I owe $20,000 in debt, but I'm unemployed, and all of my assets are exempt, meaning they can't be taken by the trustee. At this point, I owe this $20,000, but my wages can't be garnished. I'm unemployed. And there's really, since nobody can come after me, one school of thought is I don't need to file for bankruptcy now. And I can just tell my creditors that I have nothing that they can take. And so that's that. Another school of thought with the judgment-proof debtor is that filing for Chapter 7, while it's not essential, is still beneficial, because if they file, they're going to get a discharge of that $20,000 in credit card debt. And that discharge, has a lot of emotional power in a lot of cases. The idea of getting a fresh start isn't necessarily just financial, but it affects people's emotions, their vision for what they can accomplish in the future. So if there is a judgment-proof client, particularly one whose income is expected to increase, that they might get a job in the near future, then that's a decision of whether or not to file that they might want to make either way.
Hello, my name is David Doyaga Jr. I'm a bankruptcy practitioner here in New York. I generally handle between 75 to 150 bankruptcies a year, and I volunteer at Legal Services of the Hudson Valley, and I find representing clients sent to me through their organization to be quite rewarding, and I suggest it to everyone. Whatever amount that you can handle, that's up to you, but I suggest a bare minimum of one or more a year. Generally, the clients are in dire need of a bankruptcy, and this course is geared to help you handle that case. In this particular segment, I'm going to be discussing the intake. In the intake, there's three main focuses: what the client makes, what the client owns, and that's the most important part, and whom and how much the client owes. So I'm going to go over the general questions that you need. You'll find that these questions are directly related to the 341 meeting where you will meet the trustee. The first question would be, you get their name, social security number, address out of the way, pardon me. The first question would be, do they own any property? Generally, they've been screened for this, but you have to ask for the petition and their case. So I'm going to assume that they don't. The next question would be, what property does this client that is worth more than $1,000? Now, that's not the question itself, but you need to be able to protect their assets. Bankruptcy can be boiled down to those three pillars: what they make and how often, what they own, and to whom do they owe. So I asked the client, what do you own that's worth more than $1,000? That's the very, very, very quick version. What you really need to know is their bank accounts. How many? You list the amount, you list the bank, is it a checking account or a savings account, and the amount. And by the way, you need to know what they own now and what they're going to own on the day filed. Because that's the real number that we need. But to protect our clients, we have to know what they own now. Probably you'll be filing their case shortly within meeting them. So, their bank account. Do they own a vehicle? You'll list the vehicle. The petition asks about aircrafts and other things of that nature, as you'll see in Schedule A and B, which is assets. So then you will ask the client about, pay particular attention. You will not have a client that's in law enforcement, but you're going to ask about firearms. You will ask the client if they have any ATVs. Farther north that we go, this becomes very, very common, and it becomes very common very quickly. In New York City, this is not an issue, but you will see it. We need their pay stubs to produce in this intake. They may not bring it to the intake, but you're going to tell them constantly and consistently, I need 2 months of pay stubs. And that's 2 months of pay stubs from the day filed. I'm sure you're going to hear that many times in this seminar. You cannot say it to a client enough. Next, you need the tax returns. You don't necessarily need this at the intake level, but you're going to mention it at the intake level. So, client, are you married? Yes, we need the spouse's income statement if they live with the spouse. Do you have any children that live with you? Do you pay any child support? Is that through a court order or not? You don't necessarily need the court order, but if it is through court order, you need to know who it's being paid to and where that person lives, because the trustee is going to send that person a letter stating that the child support obligation is not discharged. Other questions in the intake. We've gone over vehicles, bank accounts. Here's a big one. Do you have the right to sue anyone, or are you suing someone? You'll notice in bankruptcy the questions are really geared towards what that person owns. We need to provide the trustee with this information, and in fact, if they have a lawsuit ongoing, I would suggest you get a copy of the summons and complaint, or at the very least know the name of the attorney handling the case, the caption of the case, and the index number of the case. Moving along, does the client have a stock or bond account? Do they have an IRA, 401k, KEO, or any retirement account of that sort? There's a question about pets, though I don't see any trustee dwelling on that. You also must ask about the client's household furniture and personal apparel. You will list that on the petition. That is something you will ask in the petition, but really what you're trying to find out in the intake is, do they have out of the ordinary clothing or furniture? Did the Queen of England give them a table? Do they have Michael Jackson's glove? We are not talking about the clothing that I have on today that I can get $2 for on Craigslist, and your clients will have the same thing. We're talking about out of the ordinary. That's what we are talking about. Items of extreme value. Most people, the day they bought it, it is gone. Other questions that you will need for the intake, so they will all be about value. Is there a wedding ring? Is there an engagement ring? What jewelry does the person have? So we're going to go back to that question. What is worth $1,000 or more? Why do I say $1,000 for this intake? A de minimis amount, the trustee can't action on it, can't sell it possibly. So you need to know that. So ask that client, what do you own that's worth something? And then ask it again. The client forgot. Ask a few times. Ask it a few different ways. That is how I would suggest that you handle the intake with the client. That client may come in without a document, and this is going to happen very often. Not a pay stub, nothing. But you'll still go through their assets. Then on your intake, you're going to ask them, whom do they owe? One main question is student loans. They say yes, I'd advise the client at that moment, most likely, and I won't say most likely. The technical term between us attorneys, most likely it's not going away. I advise the client student loans are not going away. It's very rare. Taxes. The 3-year rule for taxes has been discussed, but you have to list their taxes. What also must be listed in petition and therefore asked for in an intake? Do you owe any parking tickets? That should be listed in a petition. Very, very rarely is, but if you're on your game, you'll ask about that too. Hopefully by the time they file, since parking tickets and old fines are not going away, they'll have just paid it. That would conclude the information that you would need for an intake with the client. You do need everything asked, and I would tell you to get it ahead of time.
Now we've determined that the client is a good fit for Chapter 7 bankruptcy, so we have to collect a number of different documents about their finances to prepare the Chapter 7 petition. And in general, the more documents that we ask from our clients, the more people are going to drop out of the process. And so we focus on asking for essentially the bare minimum of documents that's required by the Bankruptcy Code. So there's two things that are definitely required by the Bankruptcy Code. You need last year's tax return, and you need the last 60 days of pay stubs, both of which need to be mailed to the Chapter 7 trustee. What happens if you don't have a tax return because you didn't file taxes last year? Well, then the question is, was I obligated to file taxes and I just haven't yet? Or was my income so low that I didn't need to file taxes? If my income was high enough that I should have filed my taxes, I need to do that before filing for bankruptcy because the trustee is going to ask for that. If I didn't need to file a tax return because I'm making so little money, let's say all of my income is from government benefits, then I can file what's called an affidavit of no documents. So I can file this affidavit that says I'm not sending you my tax return because I didn't have to file taxes last year, and that's fine. The other document that's really important are 60 days of pay stubs. And if I don't have 60 days of pay stubs because I was unemployed, then I put that on the affidavit of no documents that goes to the trustee, and that lets the trustee know why I don't have these documents that are otherwise required by the bankruptcy code. After those two sets of documents, there are other sets of documents that are nice to bring to the 341 meeting with the trustee. So your most recent bank statement is important to bring to the 341 meeting. Also, a valuation of your car. So we recommend going to kellybluebook.com. It's a good website. You can enter in, I have a Ford Corolla from 2002 in fair condition, and it will tell you what the value of that is. And printing that out and bringing it to the 341 meeting is a good idea so that you can be prepared if there's any question about how much your car is worth. So those are the main categories of documents that a legal services client would need in order to file for Chapter 7. And the amount of documents that I've mentioned are significantly less than what a non-legal services client would often be asked by an attorney. But again, it's really important to understand the where our clients are coming from and sort of shepherding them through the process as easily as possible. We've collected all the documents. Now we're going to start preparing the Chapter 7 petition. There's a whole lot of questions on the Chapter 7 petition, you'll see. Sometimes it stretches out to 70 pages. And before we get into the details of what's involved in that, there's three big picture things that we want to think about that are really important to get right. The bankruptcy process is designed to take assets from debtors that are not exempt and to distribute them to creditors in exchange for the benefit of getting this debt discharged, the benefit of the fresh start. And so there's three things that are really important for the trustee. One, how much money are you making each month? Two, what are your assets? This is really important, right? If you have a house in another country, the trustee is entitled to that. That needs to be listed on the petition. So getting assets right is critical. The third thing that's really important are fraudulent transfers. So if you've made a transfer to a family member in let's say the last 8 months, you repaid them on a debt, that is what's known in bankruptcy terminology as a fraudulent transfer, and the trustee is entitled to go after your family member to recover that amount and distribute it to creditors evenly. And so making sure that we get right fraudulent transfers and we list them if they're there, that's a very important piece to get right.
I am Nathan Horowitz. I'm an attorney with offices in White Plains and Carmel, New York, up in Putnam County. I've been practicing under the United States bankruptcy law since 1980, helping people with their financial difficulties. I have been volunteering with the legal services of the Hudson Valley for over 2 years and have found that very rewarding. I've been asked today to speak about the bankruptcy Chapter 7 petition and schedules. Even though I've been practicing since 1980, the bankruptcy law was changed substantially in 2005. It's ironic that one of the main reasons for the change in the forms, let alone the law, was to make it easier for pro se debtors to fill out and file a bankruptcy without a lawyer. In fact, these new forms are very tedious, sometimes too much explanation, and they're very difficult to fill out, at least especially for a pro se person. The overarching principle in preparing a bankruptcy petition is to disclose. As you go through the forms, you will see there are sometimes entries that seem duplicative. I would not get hung up on where you put the information. The most important thing is to disclose the information so that the client is sure to get the relief and not be held to be concealing that information. Even though it's called a bankruptcy petition, it's actually made up of several different parts. So I first want to run through the structure of the forms. You have first a 9-page bankruptcy petition, followed by 10 schedules, schedules A to J, to give detail and backup for the petition. You then have a 7 or 8-page document called a Statement of Financial Affairs. That is followed by a statement of intention where the client declares if they're going to keep or surrender an asset that is serving as collateral to a loan, usually a house or a car. And finally, there is a page for the attorney to disclose the compensation that they have been receiving. I will be focusing on the Chapter 7 petition, the schedules, and the Statement of Financial Affairs, which we also call the SOFA. On that 9-page petition, again, going through the forms, if you go through it carefully, it's mostly self-explanatory. I want to touch upon several specific questions. The idea of the petition is simply to identify the debtor, why they are filing in this locality, and other identifying information and affiliations that they may have. So, for example, there is the name, full address, social security number. Items 3 and 4 ask about businesses. It really is not clear, but it's talking about corporations or LLCs or other business entities and the tax ID number for that business. Number 6 of the petition talks about venue. Why is the person filing here? That is almost always going to be because they live here and have lived here for most of the last 6 months. However, there are other bases for venue in Title 28 of the United States Code, Section 1408, and the two most popular other basis of venue is where the person's principal assets are or where their business is located. I have also used the principal place where their debts were incurred. It's extremely rare to have a challenge on venue. One is supposed to file where they've lived for more of the last 180 days. Most debts being credit cards, they are national credit cards. Since 1980, I do not recall ever having a challenge on venue, even if someone has lived here for a shorter period of time. There's a question about the filing fee, whether the filing fee is being paid now or being paid in installments, so you choose one of those choices. And there are additional forms to fill out if the person is either asking for the court to waive the filing fee or to pay the filing fee in installments. Again, those are additional forms, and the details of that, I understand, will be discussed in a future segment. Now, number 12 is going to look duplicative to number 3 and 4. That is also asking about a business, but it's asking about a DBA business, a sole proprietor. And at the end of the petition, there's a place for the debtor to sign. So that takes care of the 9-page petition. And then you come to the schedules. There are schedules A through J, which is asking for a comprehensive disclosure of all current assets and financial information. So before you even begin, you want to make sure that the client has the information they need to prepare these schedules. They need a list of their assets in a general nature. They don't have to list for household furnishings every chair, sofa, table that they have. I usually would describe it as general household furnishings as an example. And they need to be able to give a value, a tag sale value for these assets. So they need that information about their assets. They need their last 6 months of income, which is a special part of the bankruptcy petition, which also will be discussed in detail in another segment. But they need their 6 months of income, and that 6 months ends at the end of the month prior to the month that they are filing. So if they are filing in July, of the year. The 6 months is January through June. They need to know their current income, what jobs or other sources of income they have now. You need to know the client's expenses, their current household expenses. This is not debts, but their living expenses. They will also need their last 2 years' tax returns, and most important of all bills. I will probably be using the word all quite a bit. I never give instructions to clients saying all except. There are very, very few, if any, exceptions. You need to know everyone that the client owes money to, even if they dispute it. The easiest way to do that is for them to gather a set of their monthly bills. Not against separating out living expenses. Some debts or bills are living expenses, like mortgage or a car loan, but usually you can draw a distinction between people they owe money to, their debts, and their living expenses. If they do not have their bills or they are not sure, they could order a credit report. There are sources online for one annual free credit report. They can also visit the county clerk where they live, and if they have moved counties recently, all county clerks, to see if anyone has sued them in those courts, which will also give you the information for the creditors and their debts. You will notice just before the schedules, there's a 2-page summary of assets. It's important, fill out the schedules first, because the summary of assets and liabilities is simply the grand total from all the schedules. So that you don't have to guess on the summary, do the schedules first, and then it becomes clear. So now we're going to schedules A through J. Again, the comprehensive disclosure of their current assets. I believe most of the entries, again, are self-explanatory. These include assets that are either in their hands, they have possession of those assets, their clothing, their jewelry, their household goods and furnishings. It also includes any claims that they have against other people that owe them money, or, for example, inheritances, that's a claim. Tax refund is a claim. If you're filing in January, February, you must disclose if the client is expecting a tax refund. And that would also fall under the category of future rights. Tax refund is a future right, but it's also an asset. A future right could also be if they're a trust beneficiary or an estate beneficiary. Someone has passed away and they expect to inherit money. These are all included in these schedules, and that's schedules A and B. So when we look at schedules, A and B are now a combined schedule, and it's set out in 7 different parts on schedules A and B. The first part is real estate. The client must disclose any and all interests in real estate, whether it's a house, vacant land, timeshare, vacation share. It is all encompassing. If you look at the form and the question, you will see the various choices in filling out those schedules. You have to disclose whether it's singly owned, jointly owned, and the type of real estate that it is. Part 2 of the schedule A and B are vehicles. And there are spaces to put in as many vehicles as you need, or you need to add an additional form. And you go through the various information about the vehicles. They want a description of the vehicle, the mileage, who owns it. If it's joint, there are spaces to put in. If both the husband and the wife are filing, they're known as debtors 1 and 2. If only one person is filing, but they own something with someone else, then it's debtor plus another. There's a box that says at least one of the debtors and another person. So that is questions 3 and 4 of vehicles. You then come to questions 6 through 15, which is part 3 of this schedule, and that is going through personal and household goods and furnishings. Will include jewelry, hobby, material that they have, sports equipment. It is all encompassing. It really is all laid out on the form with the specific examples. Part 4 of the schedules, of this schedule, A and B, is financial assets such as cash on hand. Many people get confused by that. Cash on hand is money not in the bank, in their cookie jar, in their pocket. Most people have some money. I would find it extremely rare for that question to be zero, but you will find many clients will say automatically that they have no money on hand. And then there's a question about bank accounts, and that's number 17. I wanted to spend an extra moment on bank accounts. Many clients have an account with other people, a child, a parent. You must disclose that they are on that bank account. And a very common occurrence is that, especially if it's a child or a parent, that the money is really the other person's. The client will tell you, it's not my money. You still have to disclose it. You will note that in all of the entries, there is a line for a description. You can put in the description, indicate that it is the other person's money, that the client's name is on for administrative convenience, and I would list the value at 0. Of course, if part of the money is theirs, they need to disclose how much of their money is in that account. You will also have clients that have a bank account that they are maintaining, but the account is held in another person's name. They must disclose that money, those funds. I mentioned before, I'll say it again, on this description line, for example, household goods and furnishings or jewelry, it is not my practice to specifically list every single item. It is sufficient to put general household goods and furnishings or general personal jewelry, general wearing apparel in the description. If a client has a particular item that has intrinsic value, whether it's an engagement ring, they should list that specific item. A Rolex watch, if they have something of value, an antique, they may be using it as a household furnishing, but if it has intrinsic value, it should be disclosed. Paragraphs or items 18 and 19 on this Schedule A and B is about businesses. They should list any business interest they have, even if they do some eBay sales or they're making their own jewelry and selling it. They should list that interest. It may also have been listed on that 9-page petition as a DBA business, but they also need to list it here. And if it's a business that they had up until recently and it's not operating anymore, again, that goes in the description, simply not operating. In item 21, you have retirement accounts. That's any and all type of retirement accounts, 401ks, 403bs, includes regular IRAs. I separate this out for special mention because you'll note that item 24 is specifically for education IRAs or 529 college plans. So you will see that there are questions that cover some of the same ground with slight differences. My position is I wouldn't be too worried if you do not put something in the same place that the trustee tells the client at the meeting that they should have put it in. Although I will say that education IRAs are important to note also, education IRAs and 529s, because the law requires that the last statement of this type of account be filed with the court. After the schedules A, B, we come to Schedule C, which are the assets that are exempt. It would be my expectation that the clients you are assisting are going to have all assets that are exempt. There are 2 sets of exemptions that a client is allowed to claim. There are the federal exemptions, which are directly in the United States Bankruptcy Code, and that is Section 522, and the Bankruptcy Code is Title 11. So it would be cited as 11 U.S.C. 522, and that lists all of the federal exemptions. New York State has its own exemptions, and those are introduced to you in the debtor-creditor law, sections 282 and 283, but you will see that those sections refer to many other New York State laws that have exemptions. The main exemption sections are in the CPLR, the same exemptions that a person generally has if they are a judgment creditor. So that it would be CPLR 5205 and 5206, which covers the New York homestead exemption and the various personal property exemptions that New York State allows. The section also refers, you can use all exemptions that are in any law that says something is exempt from collection on a money judgment. For example, New York insurance law 3212 exempts all proceeds and avails of life insurance policies. And there's a large exemption for annuities, also mainly covered in 3212. You must choose one set of exemptions. You cannot mix and match the exemptions. You must either choose the federal exemptions or the state exemptions. My experience is, for the most part, with the exception of the homestead exemption, a client will be much better off choosing the federal exemptions. The federal exemptions include a wild card or a catch-all exemption of $13,000. That's the maximum that you can apply to any asset. Or if an asset is partially exempt, you can use the wild card to complete the exemption. A good example would be an automobile. The automobile exemption is between $44,000 and $4,500, depending which exemption, again, you choose. If you've chosen the federal exemptions, I believe that exemption is approximately $4,400. If you have a car with no loan that's worth $6,000, you would list two exemptions on Schedule C. You would take the car-specific exemption of $4,400, and then you would list wild card exemption for the balance of the value of the car. So they can use that for any assets. It's mostly used when you choose the federal exemptions for cash and bank deposits, because there are no specific exemptions for those assets in the federal exemption. The New York State exemption would certainly have to be used if you had a homestead with a lot of equity. The federal homestead exemption is less than $30,000. I believe it's $29,875. The New York State homestead exemption is $165,000 a person. So a husband and wife can exempt $330,000 of equity in their home. That means they keep their home and still can receive relief from their debt obligations. So that's the major choices. I do believe it would be rare for our clients to have valuable homes or homes with a lot of equity, but it's certainly something to keep in mind. It's mostly going to be the wild card exemptions. The other note I would make about exemptions is that you will note on the Schedule C that there's a space to put down what is exempt. You must relate it back to the item on Schedule B that you're referring to. And you are generally required to list the amount of the exemption you are taking. For many things that are totally exempt, like household goods and furnishings, there's a large jewelry exemption. Wearing apparel is 100% exempt. You just put the same value that you put on Schedule B for those items. If the client is not sure of the exemption, there is a choice to put down 100% of fair market value up to the statutory limit. The trustees really do not like that choice being taken. They really want to see the amount put down. But again, I believe for legal services, qualified clients who mainly are appearing pro se, I believe the trustees will be okay with that if they check the 100% fair market value up to the limit that they are allowed. Following exemptions, we get to 3 schedules where they're listing their debts, schedules D, E, and F. And again, I emphasize they are required to list all creditors that they owe money to. If they happen to have a credit card with no balance on it, that they pay to zero every month, or they're simply not using, they do not have to list that card. But if they owe any amount from $1 up, they must list that debt. I think the schedules are self-explanatory. Schedule D is for secured debts, like a mortgage or a car loan. Schedule E are priority debts. There are a laundry list of priority debts. The most popular are income taxes that are less than 4 years old, child support, alimony, maintenance are all priority debts. They go on Schedule E. Schedule F then are all of the rest of the creditors, the unsecured debt, the credit cards, the medical bills, personal loans that are not secured. Now, if someone has a judgment, as you are probably aware, can be a secured debt. A judgment automatically attaches to real property, for example. It is much harder to attach a judgment to personal property unless the client has a home, a house, or a condo to where that lien is going to automatically attach. For that type of judgment, you should put it on Schedule D, and there are proceedings you can bring in the bankruptcy court then to avoid that judgment lien on the house. That is really a different topic. Otherwise, if someone simply has a judgment but they have no assets for the judgment to attach to, I would list it on Schedule F. Schedule G is executory contracts and leases. If they have a lease for where they're living, the leases can be listed here. Car lease would be listed here. Schedule H, you would list co-debtors, co-signers, guarantors. So their names and addresses are listed here on Schedule H. And of course, those creditors are also listed on Schedule F, assuming that is an unsecured debt. You now come to Schedule I and J, which is the current income and expenses. Clients must list all sources of their income. A very common error here is, on Schedule I and J, is the listing of public assistance. If they are receiving SNAP or other public assistance, it should be listed on the appropriate line on Schedule I. I is for income. And if you don't see a category that you believe it applies to, there is an other category to add that income. There's a countervailing listing for SNAP when you get to Schedule J, which is the expenses. There is a food category. Most people are likely spending more on food than what they're receiving for SNAP. You're putting on both schedules. You put the SNAP income on Schedule I. Be sure that the client lists all of the food expense, which would include the items that they purchase with the SNAP. That is still a food expense. They may be using the SNAP to pay for it, but it is their food expense. So be sure that that is properly listed. Schedule J also has over 30 categories of expenses. They've combined in these new forms expenses, which I think makes it harder. I think it makes it harder for the client. It makes it harder for the trustee to look at those expenses if they want to challenge one. In any event, you need to carefully go through the expense items with the client and combine those. My other comment generally on Schedules I and J, I would like to mention are the multipliers. Many clients get paid, looking at the income side, by the week. Some clients get paid bi-weekly. Some clients get paid semi-monthly. Semi-monthly is very easy. That's 2 paychecks a month. When I say semi-monthly, I'm referring to people who get paid on the 15th and the 30th of the month, 2 specific days. But otherwise, don't get fooled by the lack of the proper multiplier. If someone gets paid weekly and you're looking at their pay stub and they want to put down their monthly income, the multiplier is 4.3. There is only 1 month of our calendar year that only has 28 days, or exactly 4 weeks. So the same thing on expenses. If they're listing food, and I always counsel clients to give me their expenses, how they spend the money. Most people buy food by the week. They go to the supermarket once a week. They may fill in here and there, but they should be able to give it to you by the week. You would multiply the weekly expense by 4.3. Going back to income, if they get paid every other Thursday or every other Friday, that would be bi-weekly. The multiplier would be 2.15 in order to get the proper monthly income. So that is a detail that you should keep in mind. The next section of the petition is called the Statement of Financial Affairs, or the SOFA. And whereas the schedules A through J are emphasizing the current financial status of the client, the Statement of Financial Affairs looks to the recent past and requests information of financial status or financial history. It will ask, for example, in the first, one of the first several items is their last 2 years' income and their income of the current year to date. So again, the client needs their tax return when they are preparing these petitions. I find a very tricky question every time I look at the schedules themselves, as opposed to doing it on my computer program, is question number 6, where it asks whether the client has primarily consumer or primarily business debts. I find the question is extremely poorly worded, and when I look at that question, frankly, I get tripped up. The bottom line is number 6. For most of the clients, the answer is yes, which is actually the second part of number 6, that yes, it is primarily consumer debt. And then there's a question of whether they paid any creditor more than $600 in the last 3 months. Again, it probably will be very unusual for someone to have paid an average of $200 a month to a creditor, but this is where that question would go. That deals with a concept called preferences, where a client is not supposed to pay a particular creditor or prefer that creditor shortly before they file bankruptcy. A trustee can actually go back and recover that money if it's over a certain amount of money within a certain period of time. And there are 2 types of preferences. There's the general preference for any creditor, and that only looks back 90 days and is limited to $600. The other preference is to what's called an insider. An insider is a relative or a business associate, and there they look back, the petition looks back a full year, and there is no minimum dollar amount. So even $1 paid back within a year to an insider must be disclosed. There is also an additional question, number 8, which I think probably would not apply, that asks if the client paid a creditor directly that benefited an insider. So if you had a cosigner or a guarantor on a debt and you made a payment within a year on that debt, it would be listed here because the cosigner or the guarantor benefited from the fact that your client made that payment. The next schedule after the Statement of Financial Affairs is the Statement of Intention. The Statement of Intention is a statement whether a client is going to continue making their payments on a secured debt, again, usually a house or a car, and keeping the car, or whether they're going to surrender the car to the creditor or the home to the creditor in full satisfaction of the debt. If they do surrender, they don't have to pay that loan anymore. If they want to keep that asset that is acting as collateral, they must make their payments. The law, as it is written, requires the debtor to make a choice of either reaffirming or surrendering. We usually only reaffirm cars. So that is, you should be careful to put reaffirmation if they want to keep the car. You will, again, I believe it would be in another segment. There is a whole issue about whether the client should actually enter into such a reaffirmation agreement. I will say it would never be done on a mortgage. On the statement of intention, even if the client does not have an asset that is serving as collateral, the entry would just be none on the questions, and the debtor, the client, would still sign. The court is still looking for the signature. So even if this particular form doesn't apply, it should be filled out with none and signed. The last document that makes up the formal petition would be if the client did have an attorney, if you were going to appear with the client in the case, you must disclose whatever compensation that you have received prior to the filing, and whether you have promised to share that compensation with anyone, which you should not, because it is generally prohibited. There is no fee splitting allowed under the Bankruptcy Code. That covers the filling in of the petition and the schedules. Again, I'll conclude by indicating that this is a comprehensive form. A debtor, a client, is required to disclose everything that they own or have an interest in or a claim to, everyone they owe money to, their sources of income, their expenses. They need to disclose to get the powerful relief that the Bankruptcy Code offers. If you don't feel that something fits into a category, every part of Schedules A and B have a final question in each of those parts that basically says anything else. Make sure that you disclose. I want to take a moment to go back to Schedules E and F. Similar to Schedules A and B, that with the new law and the new forms they combined, with Schedule A really being real estate and then Schedule B being all of the personal property. Similarly, with Schedules E and F, two of the debt schedules are combined as one schedule. So you should be sure that you're putting in a creditor in the right place. It starts off on Schedule E, Part 1, with the priority unsecured claims. The examples I gave, the most common examples are income taxes and domestic support obligations, which is alimony, maintenance, and child support, and any other debt that arises from a divorce that would include equitable distribution. Those would be priority, and usually the forms that you will have a couple of pages for those priority debts, and you'll see there are many boxes on these schedules for you to fill in which debtor owes the debt, debtor 1 or debtor 2 or both, and what type of debt it is, and asking for other information. And then you will find yourself at Part 2 of this combined schedule, which then is Schedule F, which are the non-priority unsecured debts. Again, that is everyone else that you have not scheduled yet as either secured or priority. I hope that's a clarification. At this time, I want to go through a list of common questions that I've come across both in my own practice and in the seminars that I've provided to the legal services of Hudson Valley clients. And they have very good questions. What happens if I don't have pay stubs or am unemployed? This can be common. Firstly, if you're unemployed, on Schedule I, there is a box to check that you are unemployed. That's the simple part. However, clients will still have some source of income, whether it is unemployment compensation, disability, SNAP, as I mentioned before, other public assistance benefits, pension income. So they still are required to list their income in the appropriate places on the form. If they do not have pay stubs, the client still must be able to tell you how much money they are currently making, again, focusing on Schedule I at the moment. That's their current income. If they work on an hourly basis and different hours every week or every pay period, you will have to work with them to come up with an average monthly income to put on the form. Not having pay stubs is more important for the 6-month period. They still have to estimate for you the amount of money that they have made. Many people deposit their checks into a bank account. So that's one way they can certainly look at their bank statements and calculate their income. If they do not do that, you still have to work with them and come up with the average income. I do not believe that anyone will run into trouble if it is not exact to the penny. Following the filing of the petition, certain pay stubs are required to be delivered to the trustee. And that would be pay advices, as it's called in the law, or pay stubs for the last 60 days. If they do not have pay stubs, it's very simple. You prepare an affidavit that the client signs explaining what their job is and that they do not receive pay stubs. And the trustee will accept that affidavit, notarized, that there are no pay stubs. What if I cannot figure out the correct figures for the summary questions in the petition? I believe I did mention when I started the discussion about the schedules, do the schedules first, and at the end of each schedule there is a line to put the total for that schedule. Some of the schedules even have a total for each part of the schedules. As we went through schedules A and B, there are several parts for different types of assets. So if they do the schedules first, the summary should be easy. And the summary pages are also in the form of ranges of numbers, so you must pick the appropriate range. If I'm judgment proof, should I file bankruptcy anyway? There are reasons to file. That is something that you need to discuss with the client. If I have a client that is judgment proof, I will certainly explain that to them and explain that from a legal standpoint, they may not have to file a bankruptcy because creditors cannot collect any money from them. However, the two important caveats: number one, they may be judgment proof at the current time, perhaps they're unemployed, but that hopefully will be a changing situation and that they will in the future have a job. And if they do not file and someone has already sued or does sue them and receive a judgment is good for 20 years. So that is a long time. The client may be better served to file now, know that they have relief, and they have their fresh start under the law and don't have to worry about them getting a job. Secondly, as a practical matter, even if they think that their situation is long-term, if they do not file, they have to understand that creditors will still try to exercise their rights. They will receive phone calls at all times of the day or night. These collection agencies find out who neighbors are or relatives, and they get phone calls. So again, for peace of mind, a filing may still be considered. I've represented people in their 80s who are on retirement income and are otherwise judgment proof, and they have felt it economically viable to pay a legal fee and to achieve that peace of mind that goes with getting the bankruptcy relief. One further reason to consider filing a bankruptcy now, even if the debtor or the client feels judgment proof is with regards to assets. If their situation does change and they obtain a job and they're making money, and let's say they then go out and buy a car or buy a better car, but they discover that they're still having trouble paying their past debts and that those creditors are coming after them, a whole new exemption analysis would have to be done to make sure that the assets that they now have and the money that they may have started saving, if they would have a trouble protecting that money with the exemptions. Remember that some exemptions have monetary limits. So if people, the best time to file a bankruptcy is in fact when you are at the lower end of your economic trough, and of course everyone is optimistic that their situation is going to get better. If a car belonging to my son is in my name, or in fact, of course, anyone else, if you have a car in your name that belongs to a third party, how should that be treated? I would list the car because it is in your name. But as I explained earlier with respect to a bank account, that if there's a bank account and the money belongs really to someone else, you put that in the description, that this is my son's car. He purchased the car with his funds, that the car, for example, title might have been taken for insurance purposes in the client's name. Not even necessary to say that. Just explain that it is in reality the car, and for personal reasons that the client put the car in their name. We would like to hope that that car would still be covered by either the car exemption or the wild card exemption to make sure it is safe. But if you can lay the groundwork for the trustee that the client only has legal title and not what we call equitable title, many trustees will accept that. This is true if there is a loan or not on the car, which also means if that client not only has the car in their name but took out the loan, you must list that loan. Based on the discussions before about reaffirmation, this should not be a problem as long as the payments on the loan are made. The banks do not want the cars back, they want the monthly payments. So the loan, again, would have to be listed. If I have some items in a storage unit but owe money to the storage company and they are holding belongings for non-payment, how should this be listed? This would be listed in a few places. Number one, on Schedules A, B, you list the items in the storage unit in the appropriate category, whether it's household goods and furnishings, sports equipment, etc., with the value. And as part of your description, you can add in on that line some items in storage. When it comes to the debt that you owe the company, you must list it on the schedules, either D, E, or F, as far as the amount of money that you owe. This actually directly relates to another common question of how to determine if something is an unsecured debt or a secured debt. If the storage company has possession of the items, under New York law, that would be a secured debt. A debt is secured not just by filing a document like a mortgage or a judgment, but by having possession. So this debt would be listed on Schedule D, and in the description of the collateral, you would put down the items in the storage unit. Another example of secured or unsecured debt, if the client has something in a pawn shop, that pawn shop should be listed on Schedule D. So in general, a secured debt is a debt in which the creditor has the right to repossess the item in regards to payment of that debt. If there is no such right, it's an unsecured debt. And again, the common examples, credit cards, medical bills, are generally unsecured debts. Do repossessed items have to be listed? And if so, what if I still owe money to the creditors? There, again, are a couple of possible places for this to be disclosed. And remember, that is the optimal word on these papers, is disclosure. If it was recently repossessed, there is a particular question on the Statement of Financial Affairs that asks about repossessions, foreclosure sales, or garnishments in the year before filing a bankruptcy. So the repossessed item would be listed on the SOFA. If you are intending to ask for the item back, especially if the repossession was very shortly before filing, I would list it on Schedule B as a current asset, especially if it's a car and it was just repossessed. The title is likely still in the client's name. So you would list the asset on Schedule B as well. And if the client is intending to ask for the property back, claim the appropriate exemption on Schedule C. If the client owes money on the item, it would be listed on Schedule F, especially, but not exclusively, if the client does not want the asset back. Because once the item has been repossessed, that debt is now unsecured if the collateral has already been taken. So that now would be listed on the Schedule F. That would be Schedules EF Part 2 as an unsecured debt. If they want the item back, it would be listed on Schedule D as a secured debt. I co-signed on my child's loan or credit card. Do I have to include this? And how? Again, two places that this debt would be listed. When you co-sign a debt, there is no real primary and secondary obligor or debtor. Everyone who signed on that debt owes the debt in full, or, as you may recall, joint and severally. So the debt would be included on Schedules D, E, or F, most likely F, as an unsecured debt. In the description, you can put in, if the debtor is the one that was the cosigner, then in the description I would say co-signed child's student loan, co-signed child's credit card, and then the cosigner is listed on Schedule H. Will the court or the trustee take my engagement ring? What items of mine can they take? We could spend a whole seminar on exemptions alone, and I can only encourage you to look at the sections I mentioned before, 11 U.S.C. 522 for the federal exemptions, and the New York State law, CPLR 5205, for the personal property exemptions. A wedding band is the only item of jewelry that has a specific exemption in New York State law, and I believe it's up to a $50 watch. Other than that, there is a general jewelry exemption, both in New York law and the federal bankruptcy code. And under the federal code again, if they have some jewelry that they feel has higher value than the exemption, we have the wild card exemption. What happens if I forget to list an asset or a debt? The law allows very liberally for amendments to be filed after the petition has been filed. So at any time while the Chapter 7 is pending, which is usually 5 to 6 months, you may file an amendment, and you are required by the law, in fact, to file an amendment if you forgot, especially an asset, because that is what the court and the trustee is mostly interested in knowing about, what assets you have and if they are exempt. So it would simply be a matter of filing an amendment, taking out the same schedule, labeling it as an amendment, and filing with the court. And you serve all amendments on the trustee and on the creditor. If you're adding a debt, you must serve the creditor. What sort of values am I attaching to the personal items? Is it the price that I paid or the value by the insurance company? Very good question. I did mention a bit quickly perhaps that the value is a tag sale or yard sale value. It is not what the client originally paid for the item, even if they bought it a week ago. We have very fast depreciation of items once it's out of the store. No one is buying someone else's items. You would be surprised even to go on eBay to look at engagement rings or wedding bands at how cheaply they are sold. These items, no one wants someone else's ring. So it's tag sale or yard sale values, not what you paid for them, not what it would cost you to replace them. When it comes to the insurance, that's a little more tricky. Some trustees, especially when it comes to jewelry, will ask to see a jewelry rider on a client's insurance policy. I have always argued that those are two different types of valuations, and the bankruptcy law does generally recognize that personal property is valued based upon the intent or purpose of that item. So insurance coverages has one purpose, to really replace an item. For a bankruptcy trustee, it's what can he or she get for the item in a quick sale of that item. If I do not have any items to value in a particular line or a particular section, do I just skip that line or put 0? First of all, if you look at every schedule, the first question, maybe the second question, I think it's mainly the first, asks, does the client have any of blank? Even every question on Schedule AB on each category of personal property, for furniture, and then for jewelry, and then for collections of items or antiques, there's always a box to check no. And you would check the no box, meaning none. It never hurts to put 0 on the dollar line, but if you check the no, that will be sufficient. Same thing on the other schedules. Schedule G for executory contracts, Schedule H, they all start with the question, are there any? And you simply check the no box. I am divorced, but my name is still on the deed to my wife's house, even though I don't own it any longer. How will the house be treated? Firstly, this comes under, again, the idea of disclosure. You have to list the fact that you are on the deed to this house on Schedule A. In the description, if it applies, if the divorce judgment gives the spouse the house, you indicate that on the description, and you would list your value as 0. Remember, if you look at the schedules, it's asking for the value of the client's interest in the asset. If their interest is 0, even though they have an interest, a legal interest in the asset, you would put 0 for the value. If, as I indicated in a divorce situation, if the judgment gives the spouse the house, the bankruptcy courts recognize the divorce judgment as a transfer document. They will respect the fact that the house is no longer the debtor's. I'll make just a brief tangent here. I've emphasized in this answer the judgment of divorce. There's a big legal issue if there's only a separation agreement, but the bankruptcy is filed before the divorce judgment is entered. The divorce judgment is the key. Remember, as lawyers, that timing is everything. So if these types of issues come up, you really want to check the law, and if you're not sure, call someone. You're welcome to call me. Call someone to find out the answer to that question about timing. I borrowed money from a friend and paid it back, but he says I still owe him. Do I have to list this? I believe I mentioned near the beginning that that all means all. You list all money that someone claims you owe them even if you dispute it. There is a box all through Schedule D, E, and F. There is a box to indicate that the debt is disputed. Likewise, if the debt is conditioned upon something happening, there is a box to check that the debt is contingent. An example of that could be if the client is a guarantor for someone else. Well, their obligation to pay is contingent upon the primary obligor defaulting on that debt. What if I owe back taxes or an overpayment to Social Security or the VA? These are two types of debts that are, in fact, treated very differently. Goes without saying, you must list the debt in the proper place. Income taxes are usually going to be priority taxes. If the tax year is less than 4 years old, it's going to be priority on Schedule EF Part 1, which is the Schedule E priority debts. Overpayments that Social Security or the VA or unemployment compensation have made to you are treated as general unsecured debts. Those are not priority. Those are, in fact, dischargeable in bankruptcy, whereas the priority debt, and that's why it is called priority, are non-dischargeable debts. Can I keep my credit cards? Can I get one in the future? If you owe money on that credit card, it must be listed. If the client pays a card to zero on a monthly basis and does not carry a balance over to the future month, it is not a debt. It does not have to be listed. In all likelihood, if a credit card or any other debt is not listed, or any other person who they might owe money to, if in fact they don't owe money to at the time, it is not listed on the schedules. In all likelihood, they will keep that credit card because that credit card bank will not receive official notice of the bankruptcy. I would warn the client that some credit card banks do a random check of their customers, a random amount of their customers. They'll do a credit check. If they find out about the bankruptcy, credit is a privilege. It is not a right. So the credit card bank may, in fact, cancel the account and close it. Future credit is a big topic, of course, in bankruptcy. It's the only downside of any bankruptcy. So will a client get future credit cards? From my experience, within a year or so, many, many people are back getting regular credit if the three core bases of credit are on the positive side. Those are they have an income, they are saving some of that income, and they're paying all their living expenses on a timely basis. Of course, not just living expenses, but any other debts that survive the bankruptcy, such as car loans, mortgage loans, and expenses of that nature. If they're doing the right thing, if they're on a positive track, they will get credit. Expanding that question from credit cards and my comment about the downside of bankruptcy being on the credit report, another potential consequence, especially in the short term, is the ability to rent an apartment. Hopefully your client is in a stable living situation. They're going to be there for a while, but certainly there are many landlords, especially in formal buildings, apartment buildings, or condominiums, or co-ops, if you want to try to rent there, that they run credit checks. They're going to see the bankruptcy, and the client may receive some rejections or hesitation to be rented to. If, in fact, they're looking to rent in a two-family house where they're dealing one-on-one with the landlord, that's usually easier and that kind of landlord many times does not run a credit check. My experience has been that people do find places to live, that they will apply, even in an apartment building. They can explain the bankruptcy. Hopefully, of course, the more time that goes by between the bankruptcy and looking for that apartment, that the bankruptcy will fade back into the future. The other suggestion I tell my clients is that it's a matter of discussion, making a good impression, and a discussion of credit, that if the bankruptcy comes up, Sometimes it's really a simple matter of saying to the landlord, you usually request 1 month security, I'll give you 2 months security. And after the first year, of course, when I prove myself in payment, you'll refund the extra month and I'll be back to a regular 1 month. So many times it's just a matter of discussion. But yes, renting an apartment can be a challenge shortly after bankruptcy. If I obtain exempt income, or I receive exempt income, and also non-exempt income, can I just have one account or should I separate them? And here we're talking about bank accounts. This is a question, again, goes a little bit to the timing issue I mentioned before. But absolutely, if I have a client that is receiving Social Security or pension income, but they also have a part-time job, or maybe their family helps them out with income every month, I would separate that money. You want to be able to easily identify to the trustee income that is exempt. Have a checking account into which only goes the Social Security or the pension income or any other exempt income, the disability income, unemployment compensation. Keep that money separate, and of course, if it's direct deposit, it's even easier, because then if a trustee asks, you can show the last 2 or 3 bank statements, and the trustee is convinced that is all the money that is in that account is exempt. Another example is child support or alimony. This is exempt money. The trustee is not going to touch that money. But if you have other regular income that is always available to pay creditors, regular wages, family assistance, do not commingle that money. Have a separate account. And I'll take it one step further, try to explain to the client that when they're paying their living expenses, spend the non-exempt, unprotected money first. Many clients get confused and they think you're telling them that they shouldn't spend their child support or they shouldn't spend their Social Security. That is not the point. The point is spend the unprotected money first. Of course, they're going to need the other money, and they should use it as they need it, but maximize the protected money. If I have 2 vehicles that together are less in value than the total vehicle exemption, can I list both of them under the same exemption? The answer is no, but there is a flip side to that question, actually. So if you have 2 vehicles, you can only apply the exemption to 1 vehicle. If you are taking the federal exemption, you can, of course, use the wildcard exemption for the other vehicle. The flip side of that question is, although this is rare, if you have a husband and wife client and they have joint title to that car, you can double the exemption. So if the exemption is $4,400, you now have an $8,800 exemption in that car. If I have one creditor with numerous claims, should I list each claim separately or add them all up and put them on one line? If it is truly the same creditor with the same address listed on the bill, I would add it up and list it once on one line. There is a space on the schedules D, E, and F for one account number. And in the description, I would add the other account numbers. There are some credit cards or some banks that issue different credit cards. For example, for the Gap or for Toys R Us, they may be backed by the same financial institution, and they may in fact have different addresses. You must look at the bill and see, first of all, whether there is a specific bankruptcy address listed, or number 2, whether if they don't have a bankruptcy address listed, if what their correspondence or dispute address is. There's no wrong answer. They certainly can be listed separately as separate entries on the schedules. I probably would not list more than 3 or 4 combined on one entry, but certainly if there were 2 or 3 accounts with the same bank at the same address, I would list it once and add up the total amount due and make sure to list all 3 account numbers. Will future employers be able to see that I filed for a bankruptcy, or anyone else? Bankruptcy is a public record. Anyone can go to the bankruptcy court and look to see who's filing a bankruptcy. I find it extremely unlikely, and especially in this electronic age that we're in, where many bankruptcies by bankruptcy attorneys certainly are filed electronically. The records are also accessed electronically, and you have to have a username and a password, and generally only lawyers are able to get usernames and passwords. It has been my experience that people do not research or check bankruptcy filings, and there is no public publication of bankruptcy in newspapers or as such or online. Certainly not that I have ever seen. But the technical answer is yes. Someone can find out that you filed a bankruptcy if they went to the trouble to look it up. What if creditors keep calling me after I file? Should I tell them that I filed, and how? Creditors are legally prohibited from calling you once you file. And this prohibition is automatic. There are no special notices that the creditor has to receive. Creditors are deemed to have actual notice of a bankruptcy filing at the moment it is filed. We know as a practical matter that is, of course, not true. So a client should be advised that if a creditor calls, the client should, in a courteous way, respond, I have filed a bankruptcy. They should provide that creditor calling with the filing date and the case number that they will receive from the court when they file that petition. They should be sure to ask for the name of the person that they're speaking with and note down and keep a record of the date and the person and the creditor that called, so that if it does happen again, they can then send a letter telling them that they're in contempt of the bankruptcy code. I certainly wouldn't claim a contempt from one phone call, but they should give them the filing information, and that should solve the problem. They can tell the person on the telephone if they were bothered a second time by the same creditor. I certainly would put it in writing, because you will need a written notice in writing if you were going to go to the bankruptcy court to ask that a penalty be imposed on that creditor for harassment. But on the first go-around, the simple response by telephone should be sufficient. What happens to money that I have in the bank? Will the trustee take it? This is a question that comes back to the exemptions. New York state law has a cash exemption if there is no homestead. For some reason, New York legislature made a compromise that if you own a home, you don't need any cash. Although unexplainable, that's the way it is, and the New York allows you to protect up to $6,000 in cash if there's no home. Again, the federal exemption has the wild card up to $13,000 that would be used to cover cash. Any asset that's exempt, whether it's cash out or in the bank, cars, anything that's not exempt, the trustee has the right to take control of and use to pay creditors. I have a mortgage on my house. What happens to it if I file? Generally speaking, if a client wants to keep their home, house, condo, co-op, as long as they make their payments, they have a mortgage contract that says that the bank can only take enforcement action if they fail to make the payments. That contract survives the bankruptcy. So if the client wants the house, they continue making their payments. I mentioned before, there is a concept called reaffirmation. They may receive from their mortgage bank an invitation to reaffirm with a form. The bankruptcy courts in our district here will not approve the reaffirmation of a mortgage. It is only generally done with cars. So the only issue on the mortgage is actual payments. I will add to that just to say, just a general concept, that bankruptcy discharges debts. Bankruptcy does not automatically discharge liens. So although, technically speaking, the mortgage debt, the obligation to make the monthly payments, is in fact discharged by that Chapter 7 discharge, the discharge has no effect on the mortgage lien. The mortgage is a lien. So it does not discharge the bank's right to foreclose if payments aren't made. So again, the simple, practical result of that is if the client wants the home, they make the payments. And they make the payments whether they receive a monthly statement or not. Some banks stop sending statements while the bankruptcy is pending. Your client should know how much they pay monthly, and they should have the address to where they pay, and they should make those payments writing the account number and the month that they're paying on the check. They should keep a copy of their checks. What if I want to pay certain creditors, such as my personal doctor, whom I want to continue a relationship with? Can I prioritize who gets paid? Let's first remember that as far as prioritizing and paying, that would be the bankruptcy trustee's function if there was an asset to pay. There is a priority scheme or schedule as to which creditors get paid first. The client, him or herself, does not have a right to prioritize, even if there are assets, to tell the trustee who to pay first. What this issue and question really goes to is simply the way the question is initially stated: can I pay certain creditors? We start off with the rule that all creditors must be listed. If after the bankruptcy a client comes into money and wants to pay a certain creditor, and many times a personal doctor is the most popular, or it could be a relative, there is no prohibition against your client doing that. So if they gratuitously or out of a moral obligation want to pay a creditor, they may do so. Again, they must list that creditor on the schedules. Should I go shopping right before I file to max out my credit cards? Your clients will probably get that advice from some of their friends. The answer is absolutely not. And especially in the recent past, creditors will look at bills going back several months. I usually believe that 3 or 4 months is, a safe period, and I ask my clients what they've charged in the last 3 or 4 months. But creditors can go back 8 months, 10 months, especially if it's a high balance, and that could be seen as a type of fraud. You cannot run up your bills and then file a bankruptcy. First thing you should tell a client when they come to see you is that if they're thinking about filing a bankruptcy, they must stop using the cards. That's cold turkey. There are sometimes an issue with whether they should make a couple more payments to a particular creditor, especially if they've made recent substantial charges, but that's getting into a little bit too much detail for today. But they certainly should not max out their cards. Finally, as a common question, do I have to list my spouse's income and expenses? And the answer is yes, and again in 2 different places. You have Schedule I, which has the current income. Especially if you're living with your spouse, if you are separated and you're not, and the spouse's income is irrelevant, you do not have to list it. But if you are living together as spouses, Schedule I would require the spouse's income to be listed. Of course, don't forget that when you do Schedule J, the household living expenses, you are listing the expenses of the entire household. Spouse, children, anyone else that is living with you or that you are supporting. So the law wants to see, and the trustee wants to see, whether there is money left over. I have had a couple, not too many, a couple of clients where the spouse really made a very good income and the client made very little income, and the combination of the incomes really showed that the household can pay their expenses. We have still filed, and I've made it clear to the trustee that the person by themselves can simply not pay their debts, and the spouse or any other third party is not legally liable to pay the debts of another. So their income really is not, should not be counted to, as a negative to tell the client to file, say, a Chapter 13, which is a payment plan to pay part of the debts. The second place that a spouse's income is listed is on the 6-month means test that I mentioned before, that will be covered in another segment. But if the spouse has income, then that 6 months of income will also need to be disclosed on the means test. I will just say that just like I mentioned about Schedule J expenses, and even more important on the means test, as you will learn, the non-filing spouse's personal expenses, which are part of Schedule J, which is why I'm mentioning it in this segment. So that spouse has their own expenses. That's not filing. That spouse has their own cell phone. They have their own medical bills. They likely have their own credit cards that they're making monthly payments on. They may very well go to work and buy food out of the house just for themselves, not for the household. Those personal expenses, although again part of Schedule J, they can be backed out of the means test, which will of course help the client pass this technical 6-month income test. So those personal expenses can be backed out of the income when you're listing it on the means test.
Hi everyone, my name is Wendy Marie Weathers. I'm a practicing bankruptcy attorney in Westchester County, and I have been volunteering with Legal Services of the Hudson Valley for many years now, and I find my work with the organization not only gratifying and rewarding, but also humbling. So I'm here today to help out in training. There's a couple issues that I wanted to go over when it comes to bankruptcy, and I'm going to discuss the Statement of Financial Affairs, which is also known as SOFA, the Statement of Intention, the means test, attorney's compensation, and also counseling. So first I'm going to go through the Statement of Financial Affairs. And in your handout you should find the forms. And I wanted to not only talk about the forms, but also for you to understand the purpose behind the form. And the purpose behind the form is to treat all creditors equally and not favor one creditor over another, which means while favoring one creditor over another won't result in a crime, intentionally defrauding a creditor will result in civil and criminal prosecution. So this form is utilized to help the trustees correct any unfairness suffered by your creditors as a result of your recent bill paying or any other transfers, and by gathering information about what you did financially and up to 10 years before your bankruptcy, which is usually the look-back period is about 2 years. So when going through the Statement of Affairs, which is quite a few pages, there are multiple questions that you have to answer. In order to answer those questions, it's helpful to have the documents that are necessary depending on the years of the look-back that the trustee will be referring to. So within 90 days of filing, you want to make sure that you include any payments made to one creditor over $600. That means any mortgage payments, car payments, medical bills, credit card payments, utility bills, taxes, student loans, domestic support obligations, or any other loans. You also need to provide current information about your marital status, the property in your possession, which is owned by someone else, and any environmental issues with your property. You want to provide a year's worth of information about any types of payments or transfers you have made to insiders, which means family members or business partners, because the trustee will ask you if you've made any payments to a family member within a year. Any lawsuits, repossessions, or foreclosures, property that was garnished, attached, seized, set off, or levied against, any loss from fire, theft, accident, disaster, or gambling. This, again, you have to provide a year's worth of this information, as well as any status of financial accounts, including deeds, instruments, safe deposit boxes, and any storage units. Next, you also need to have at least 2 years' worth of the following information: all sources of your income, which includes wages, business income, government benefits, pensions, and interest received, including all year-to-date amounts. Also, any gifts totaling over $600 given to any one person or charity, and any property transfers sold or traded. So if you sold a property within the past 2 years, you have to disclose that in the SOFA, the Statement of Financial Affairs. Additionally, you have to provide your previous address over the last 3 years, your ownership interest in any business during the past 6 years, whether you lived as a married person in a community property state during the last 8 years, and any money you deposited in a self-settled trust within the last 10 years. So when you have all that information, then you're able to go through the questions that are listed in SOFA. I'm not going to go through the questions one by one, because if you look at the questions, you'll be able to answer it with the information that you have in front of you. Now, once you complete that information, you have to make sure that you sign SOFA. And what that means is when you sign it, you're signing under penalty of perjury, stating that all the information you've provided is true and correct, and that if you are making any false statements, that it is punishable to a fine of up to $250,000, imprisonment for 20 years, or both. So it is absolutely imperative that you be truthful and disclose all the information as I listed. The next section that I'm going to discuss is the Statement of Intention. The Statement of Intention in a Chapter 7, also as the SOFA, has a purpose. It's to inform the court, the bankruptcy trustee, and your creditors about what you intend to do with your property. Now, the form breaks it up into 2 parts. Part A is property secured by a debt, securing a debt. That means if a creditor has a security interest on your property, its debt is considered secured in bankruptcy. Secured creditors typically have a right to repossess or foreclose on your property if you don't pay back your loan, as agreed. And the most common examples of secured debt is a mortgage and a car loan. The other part of the Statement of Intention is unexpired personal property leases. If you have a personal property lease that's in effect when you file for bankruptcy, you'll include it on the Statement of Intention. A lease is a type of contract that allows you to use property for a period of time. When the lease period is over, you give the property back. A personal property lease involves any type of property other than real estate, such as a car, paint sprayer, or a wood chipper. So, the first thing you're going to do with a Statement of Intention is you're going to complete Part A. And that is the listing your creditors who have secured claims. The first thing you're going to do is you're going to insert the name of your secured creditor. And in the box where it says describe the property securing the debt, you want to make sure that you use the same description as you used on Schedules A and B and E and F in your schedules. You want to check the box indicating what you want to do with the property that secures that debt. Now, there are quite a few boxes that could be checked. So I'm going to go through each box and what they each mean so you have a good understanding of what you're checking off. You could do one of 4 things. You could surrender, which means give back the property to the creditor. You can retain, which means keep and redeem the property. You can keep the property and reaffirm the debt, or you could take another action. So, in order for you to know what option, you need to understand what the options are. So to go into further detail, surrendering the property means letting the property go. You just give the property back to the creditor. This is a good option if you don't need the property. If you can't afford the payment or the property is worth less than you owe. This approach also prevents the creditor from coming after you to collect the remaining balance you owe. So if you surrender, you give it back to the bank or the creditor, and you don't owe anything. The next thing you can do is you can retain the property. Some creditors will allow you to keep the property without reaffirming or redeeming, as long as you remain current on your payments. The creditor would still have the right to repossess at any time, though often the creditor accepts the payments and turns over the vehicle's title once the debt is paid. Because no contract exists between you and the creditor, however, your payments aren't reported to credit bureaus. The problem here is that timely payments won't help rebuild your credit. So what this means is if you want to keep the property and you don't want to reaffirm or redeem, you're just going to keep paying on it, you can continue to pay, and once you finish paying it, such as a car, you'll get the title. However, in making those payments, you're not going to improve your credit score because the payments are being made in the bankruptcy. Another option is to redeem the property. Redeeming the property allows you to pay your creditor what your property is worth, that's the replacement value, instead of what you actually owe. For example, if you owe $10,000 on a car and the car is worth $5,000, you can redeem it, which means pay it off, for $5,000. While redeeming property can be a money saver, most people who file bankruptcy cannot come up with an entire lump sum, which is required to redeem. And you also should be aware that you can't redeem real estate or business-related property, only consumer personal property, such as a car as I used in the example. The last option is you could reaffirm the debt. What does reaffirm mean? That means when you reaffirm, you put it back into a contract. So, for instance, filing for bankruptcy cuts all your contracts. But if you want to keep a certain contract, say for instance a car loan, you can reaffirm that debt by signing a reaffirmation agreement. Some creditors will actually require a reaffirmation agreement if you want to keep your car. Understand, however, that once you sign, you become responsible for the entire outstanding balance, so it's important to carefully consider your options before reaffirming a debt for property worth less than what you owe. What that means is if you want to reaffirm, you want to continue paying your car, and the creditor asks you to sign a reaffirmation agreement, which is essentially a contract, you're reaffirming that debt. You're signing a brand new contract saying you owe all that money. That will not be dischargeable in a Chapter 7 if you sign that reaffirmation agreement. So it is very important to understand what it means to reaffirm a debt. It's as if you never included that debt in the bankruptcy. The next thing you're going to do is, now that you've gone through Part A of the debtor's statement of intention, you're going to complete by checking off whether the property, the last piece of Part A is whether the property is claimed as an exemption or not. So make sure that you check whether you claim the property exempt on your Schedule C. The second part of the statement of intention is personal property subject to unexpired leases. You'll provide information about your personal property leases, but do not include leases for real property such as a leased home or apartment You only include the name of the lessor, which is the person or company holding the lease. You describe the leased property, and you check the box indicating whether you plan to assume or keep the lease. Usually, this is dealing with a car, if you have a car lease, where you will put this information in here. So you want to make sure you have the lessor's name, you describe the property as you did on your previous schedules, and then you check off on whether you're going to assume it or not. The next piece is you're going to sign and date the form. After you sign and date it, you have to file the form. And the form has to be filed with the court and delivered to the creditor and whoever holds the lease within 30 days of filing the bankruptcy, or by the first day of the creditor's meeting, whichever comes first. So you'll be given a notice of it's called a 341 creditors meeting, and you want to make sure that you file it either before that date or 30 days of the filing of whichever comes first. If you don't do it on time, you could lose the personal property. The next section that I'm going to cover is the means test. And I'm going to discuss this in two parts. One, because for the most part, the statement of your current monthly income form will most likely be the only form that you need to use. That's the form 122A-1. So, but before we get into the forms, I just wanted to go through the purpose of the means test so you understand why we have to complete these forms. In New York, and if you want to file a Chapter 7 bankruptcy, you must pass the means test. And it applies to higher income filers, which means that if your income is below the New York median, you are exempt from the test, and you can file a 7. Now, how do you determine if you're exempt? You determine if you're exempt from the means test if, after filling out the form 122A-1, which is called Statement of Your Current Monthly Income, and you find that you are below median, then you pass without having to further take the means test. So, but before we get into that, I wanted to also discuss what happens if your income is higher than the New York median. Then what do? Then you need to use form 122A-2 to determine if you can pay back a portion of your unsecured debt through a Chapter 13. Now, some people may not even have to take the means test. There are a few filers who are exempt from taking the means test, and those are disabled veterans, filers whose debts are primarily business debts, and certain members of the Armed Forces Reserves and the National Guard. So let's draw our attention to Chapter 7 Statement of Your Current Monthly Income form. That's form 122A-1. And that's a few pages long, and the first part of the form is called Calculate Your Current Monthly Income. What you need to do in the first part of the form is you have to provide the court with information about your marital status, filing status, and all sources and amounts of your income. So first, your filing status. On the first line of Part 1, you check the box that best describes you. Your answer to this question determines whose income must be reported in Part 2. If you are single, you check the first box and only report your income in Part 2. If you and your spouse file together, you check the second box and both of you report your income in Part 2. If you are married, but your spouse doesn't file, then you may or may not have to include your spouse's income. To determine this, you start by checking the box that best describes your living and marital situation. You have two options: living in the same household and are not legally separated, or living separately or legally separated. If you check the first option of living in the same household and are not legally separated, you must report your spouse's income. If you are living separately or you are legally separated, you do not have to report your spouse's income. So it's important that you understand that you check this box under penalty of perjury. And that means you should be prepared to prove your marital status, because it's fraudulent to check this box without the right to do so. On lines 2 through 10 of Part 1, you're going to list all the sources of income for the full 6 months before filing bankruptcy. For example, if you file for bankruptcy on August 15th, you include all income information for the period of February 1st through July 31st. The income figures you provide on 122A1 may be different from the numbers you included on Schedule I, because that schedule asks for your current income, not your income over the prior 6 months. So don't be worried if those two amounts don't match. You should report all income other than income you receive under the Social Security Act, because there's a separate line for Social Security income. So the income that should be reported through in lines 2 through 10 are your gross wages, which is salary, tips, bonuses, overtime, and commissions before your payroll deductions, alimony and maintenance payments, regular payments you get for household expenses, net income from operating a business, profession, net income from rental and other real property, interest, dividends, and royalties, unemployment compensation, pension or retirement income, and all income from any other source. So be sure that you state each amount as a monthly figure, regardless how often you receive that income. On the last line of Part 1, which is line 11, you'll total that amount in each column and add together that income to come up with your total monthly income. Now that you have your total monthly income on line 11 in Part 1, the next thing you're going to do is you're going to determine whether the means test applies to you. In the second section of 122A-1, you compare your annual income to that of the median income in your state for the same household size. So to do that, you multiply the figure you came up with in Part 1 by 12. This is your annual income. You then compare it to the median income in New York. I've listed 4 different incomes depending on the number in the household. If you are one member household and you are at $51,408, then if you are less than that, you pass. If you have less than $66,056 for a 2-member household, you pass. If it's $75,870,000 for a 3-member household, you pass. And for a 4-member, it's $91,998. And for each member in excess of 4, you're going to add $8,400. So if your income on line 11 is less than your state median income, you pass, and you don't have to do any further calculations. On the front top right hand corner of page 1 of the form, you can check off number 1, there is no presumption of abuse. And then you do not need to go on and complete the second form. If your income is more than the state's median income, meaning if line 11 was more than $51,408 for a 1-member household, then you have to do more calculations to see if you qualify for a 7. Then on the top of the form, you have to check the second box, which states the calculation to determine if a presumption of abuse applies will be made under Chapter 7 means test calculation. So that you sign the bottom of Form 122A-1, and if you are below median, you don't have to go on to the next form. If you're above median, we're now going to go to official Form 122A-2, and that's called the Chapter 7 means test calculation. So at this point, it's best to obtain assistance from an experienced bankruptcy attorney, because you're going to be putting in a lot of figures and amounts, and you're going to have to be referring to the U.S. Trustee's website for the national amounts that you're allowed to use. So when dealing with and completing Part 2 of the Form 122A, there's a few standards that you're going to be completing. The first is the national standard by the IRS for food, clothing, and other items. Now, taxpayers are allowed the total national standards amount monthly for their family size, so without questioning the actual amount spent. In your materials, I have provided the information for up to 4 persons in a family for food, housekeeping supplies, apparels and services, personal care, and miscellaneous. So, for instance, if you're trying to determine what to fill in on line 6 of the Form 122A-2, and you're a family of 2, you're going to enter $1,132. The next section of the form establishes the minimal allowance for out-of-pocket healthcare expenses. Taxpayers and their dependents are allowed the standard amount monthly per person basis without, again, questioning the actual money spent. So if you are under 65 years old, the national health care expense monthly would be $49. If you are 65 and older, your monthly expense is $117. The next section is going to be dealing with housing, utilities, transportation. And these are all based on local standards, which vary by location. Now, in most cases, a taxpayer is going to be allowed the amount actually spent or the local standard, whichever is less. Now, I would be remiss if I didn't refer to each county and where you would be filing depending on what county you lived in. So, understanding that legal services of the Hudson Valley transcends 2 bankruptcy districts, it's important to note that for Dutchess, Orange, Putnam, Rockland, and Westchester, you're going to be filing in the Southern District. For Sullivan and Ulster, you're going to be filing in the Northern District. So, and I've also broken down in the manual what the family size and expense type would be depending on the housing, whether you have a mortgage or no mortgage, or whether you rent, and depending on your family size. Now, another section of the Chapter 7 means test calculation includes local transportation expenses, so which could be broken up into 2 parts. 1, the national figures for monthly loan or lease payments referred to ownership costs, and 2, additional amounts for monthly operating costs. The operating costs include maintenance, repairs, insurance, fuel, registrations, licenses, inspections, parking, and tolls. These amounts do not include personal property tax. Ownership costs include for the lease or purchase of up to 2 automobiles, a single taxpayer is normally allowed one automobile, and for each automobile, taxpayers will be allowed the lesser of the monthly payment of the lease or car loan or the ownership cost shown on the table that I've provided within in the handout. So for nationally, your ownership cost for one car is $485. For two cars, it's $970. So if your car payment is $490, then your car payment, all you can list based on the national standard, is $485. If a taxpayer has no lease and no car payment, your ownership cost will be $0. Operating costs is the lesser of the actual money spent for operating costs or the figures as provided in the handout. So for New York, if your operating cost is $299, that's the local standard is $299 for one car, and your operating cost is $300, then you can only take $299 in your means test. The next section is dealing with public transportation. And there's a single nationwide allowance for public transportation based on the Bureau of Labor Statistics for train, buses, taxis, ferries, etc. Taxpayers with no vehicles are allowed the standard amount monthly per household without even questioning the actual amount spent. If a taxpayer has a vehicle and uses transportation, expenses may be allowed for both, provided they are needed for the health and welfare of the taxpayer or family or for the production of income. However, expenses allowed would be actual expenses incurred for the ownership costs, operating costs, and public transportation, or the standard amounts, whichever less. So you can't have it both ways. It's either you can get what you expend actually or what the national standard is, whatever is less. So the National Public Transportation Standard is $189 a month. So if you're spending $400 a month on public transportation, you're only going to get $189. The total number of persons allowed for necessary living expenses should be the same as those allowed as exemptions on your most recent year income tax return. You can't be different. Your total number of people cannot be different from your most current tax return, which is going to be an item that you're going to be providing to the trustee. So what happens after you fill out all these numbers and you figure out what the local standards are? Then you can determine whether you're still going to fit within a Chapter 7 bankruptcy. So if your total monthly income over the course of the next 60 months is less than $7,475, then you pass the means test and you can file a Chapter 7. If it is over, then you fail the means test and you don't have the option of filing a Chapter 7, meaning that there's this gray area. So if it's less than $7,475, after you go through the 122A-2 form, then you can still file a 7. If the amount ranges between $7,475 and $12,475, that's a gray area which is definitely going to require the experience of a bankruptcy attorney. If it's over $12,475, you fail the means test and you cannot file a Chapter 7. You most likely have to file a Chapter 13. So that completes my discussion of the Chapter 7 means test calculation form. The next form that I'm going to be going through is called the disclosure of compensation of attorney for debtor. The attorney compensation form, which is covered by Rule 2016, subsection B, states that every attorney for a debtor, whether or not the attorney applies for compensation, shall file and transmit to the U.S. trustee within 14 days after the order for relief, or any time as the court may direct, the statement required by Section 329 of the Code. This means that if you are a volunteer with legal services of the Hudson Valley and you're assisting in the filing of a bankruptcy petition, you still need to complete this form even if you're not being compensated. And you're going to enter the legal fee of $0 to reflect your compensation. The next section that I'm going to discuss is the counseling requirements. Before you can file for a Chapter 7 bankruptcy, you must consult a nonprofit credit counseling agency. And the purpose of this consultation is to see whether there is a feasible way to handle your debt load outside of bankruptcy without adding to what you owe. There's two sections that I'm going to cover within the counseling. One is the counseling itself. To qualify for bankruptcy relief, you must show that you received credit counseling from an agency approved by the U.S. Trustee's Office within a 180-day period before you file your bankruptcy. Once you complete the counseling, the agency will give you a certificate of completion that you must file no later than 15 days after the bankruptcy filing date. Bankruptcy law requires that you participate in counseling, not that you go along with whatever the agency says. Even if a repayment plan is feasible, you aren't required to agree to it. However, if the agency does come up with a plan, you must file it along with your bankruptcy papers. So there are costs associated with counseling. Credit counseling agencies can charge a reasonable fee for their services. However, if a debtor can't afford the fee, the counseling agency must provide services free or at reduced rates. Now, there's exceptions to the counseling requirement. You can avoid it if you certify to the court's satisfaction that you had to file for bankruptcy immediately, perhaps to stop a wage garnishment or foreclosure. You are unable to obtain counseling within 5 days after requesting it. If you can prove that you didn't receive credit counseling for those reasons, you must certify to the court and complete the counseling within 30 days after filing, which means you're going to ask the court to extend this deadline by 15 days. You may also escape the credit counseling requirement completely if, after a notice and hearing, the bankruptcy court determines that you couldn't participate because of, 1, a physical disability that prevents you from attending counseling, but this exception may not apply since there's a lot of counseling available over the internet and over the phone. Another reason would be that mental incapacity, you're unable to understand and benefit from the counseling. Or 3, your active duty in a military combat zone. The information related to both of these courses will be provided to you by Legal Services of the Hudson Valley. Thank you for allowing me to train you today, and I wish you luck on your Chapter 7 bankruptcy filing.
And I will now present the section on the 341A meeting. So, to prepare for the 341 meeting, you start immediately after the filing of the petition. I assume you'll be filing electronically, or if you file it in person, whatever it may be, you will be assigned a trustee within hours of the filing. Of course, you have your case number. So, first things you need to know. The trustee is most trustees want to be sent a physical copy of the petition. This is a signed copy. Electronically, the court may have received it via a filing company, a best case or whatnot, without a signature, but you are going to provide the trustee a signed live copy. It can be a copy, but a signed version of it. I would send this within a week of filing. The trustee must receive it, I would tell you, 10 days ahead of time. The trustee is also to receive the statutory 60 days of pay stubs that each filer of bankruptcy needs, or the affidavit substitute saying why or if there are no pay stubs. The 2 years of tax returns, which I suggest to all my clients are signed and dated. Otherwise, then what is it? Is it even a document if it wasn't? That has to go to the trustee minimally. Your client may have had some small-time assets, I would assume, and you may send them the appraisal of the car or something to that effect. Maybe the bank statement if the trustee is asking for it. I would send that within a week of getting my court date to the trustee. Many trustees use an online portal for these documents. They will send you an email to the email that you've provided the bankruptcy court. You will get a login. It is not complicated. You will get it done. The number one thing for you to do in terms of the trustee interface is, not surprisingly, get the trustee the documents timely. If you want a happy trustee, you will do that. You also show up to your meeting on time. And you'll try to have that client come in on time also. So that's 3 weeks out. I would discuss with the client immediately after filing, as soon as I got that court date, when the court date is, where it is. The bankruptcy court is going to send them a notice. Your client will not be able to read it. I would write them a letter telling them when it is in very plain English, and I would make the address and the time a separate section of the letter where they could find it immediately. The bankruptcy's notice is hard to follow for attorneys and near impossible for a debtor. Do not rely on the bankruptcy court to get your client there. You'll find yourself there alone and you'll be going back. Now, the 341A meeting. On game day, the day you have the meeting, I'm jumping ahead for a second, the client must have their social security card or acceptable substitute, like an original W-2 form. It needs to be an original social security card, not a copy. I'm stressing it because it needs to be stressed. If they do not have proof of their social security number and proof of who they are, you will be going back. Now, let's pull back a little bit. I've discussed with the client when to go, where to go. I tell them to get there half an hour early. Actually, I'd tell them to get there an hour early. So if they're late, they're still quite early because you're going to prepare them before the meeting. A week out, I call them again. You're coming, right? You know what to bring, right? Social security card. In fact, if you ever are a bankruptcy practitioner, you'll realize that in every conversation you have with your client discussing a court date, you discuss that social security card. Because once they start to forget it and you start to go back, you'll realize why. In fact, in your retainer, you bring your social security card. So we've discussed it again. This is the big day for the client. Bankruptcy is won via paperwork, but for the client, this is their day in front of the judge. You're not seeing a judge, you're seeing a trustee. You may explain that to the client, they probably will not get it. However, this is the de facto judge for them. You cannot lose a bankruptcy in front of a trustee. You can only lose a bankruptcy in front of a judge, but you can win a bankruptcy in front of a trustee. Because once he makes a no distribution report, meaning there's no assets to administer, you really can, in fact, win it. The judge will sign the discharge 60 days after the meeting. Anyway, the day before, I call my clients and I tell them, we got it. And I actually call my clients the morning of, because this is the moment the second biggest moment of anxiety is the morning of. Very rarely do they go to court. Maybe they had a divorce, maybe they had a speeding ticket, but very few of your clients will be court savvy, I assume. They're very nervous. You go over the address again. You go over what to bring again. No, if you said it 6 times, you've said it's 10 times too few. Social security card. Yes, I'm hammering it. Yes, you need it. You meet them, the 341 room. Outside, I meet the person and I bring them in the room. So now that they see there's no black robe, there's no oak dais, there's a room of people waiting for their meetings. It is not a hearing in front of a judge, it is a meeting in front of a trustee. That brings, because they're quite nervous at this point, they start to see what it is. First I show them the room, then I bring them outside and we go over the entirety of the meeting. I explain the trustee's motivation. The trustee is not really concerned with what your client owes. Your trustee is concerned with what your client owns. The trustee's motivation for the day is to verify documents, see if your client's situation fits within the bankruptcy code, meaning, can they win? Can they statutorily win? And third, and most importantly, is does your client have anything for which I can sell and make some money? That's where the real lawyering comes in. Your client is going to want to discharge to get rid of their debt. That's bankruptcy 101. But real bankruptcy is, can you keep that client's stuff? That idea has been touched upon. And this is the meeting where the trustee is verifying who the person is, do they have the right ID, and do they have any stuff, assets to liquidate? That's the trustee's motivation. The meeting is audio taped. The client must respond verbally. Yes and no will not work today. And you're going to prepare that client ahead of time. I tell the client exactly that. You need to speak. And we go over the questions, which are in the petition, to get them ready. I tell the client, I will be flipping through your petition during the meeting. It's not to distract you. I'm trying to be on the page of the trustee. In case you stumble with a question, and you really need to know the petition, if the answer is in the petition, I put my finger next to the answer and I tell my client, read that number. If I'm not doing it, that answer isn't in the petition, which is very, very rare. Most questions are right in the petition. So I explained the trustee's motivation. We've seen the room. Now I'm going to do the mock meeting right outside. They pass the IDs up. They sit down in front of the trustee. I'm on the side. David Doyaga, admitted to the Southern District. Besides me, appearing on behalf of the debtor. Besides me is the debtor. Okay, the trustee's going to start. First question is, do you own any property or have you ever? Second question, do you own a vehicle? Sometimes I see my clients getting nervous immediately because they've seen TV and they are waiting for the moment where the crowd goes, aha. This does not happen in a 341 meeting. I'm now on case number 2000 in my brief 12-year career. I have yet to object in open court. The client is waiting for drama because that's all they've ever seen. There will be no drama today. I tell my client, this is the easy answer room because they're going to ask you about your life and you're going to know the answers. Yes, I'm preparing them again, and sometimes they don't even know. So, you own a vehicle, you discuss the vehicle. Do you have any bank accounts? You discuss the bank accounts. Do you have the right to sue anyone for any reason? Now, when they say yes, this will now be an asset case, and the trustee is going to administer that. This other idea of, I've asked the client previously, what do you own that's worth more than $1,000? You'll find the trustee's questions are tailored to what this person owns. Do you have the right to sue anyone? Is anyone holding any property that belongs to you? Some trustees like to ask the question, what's the largest amount of money you've had at any one time in the past year or 2 years? I ask that question outside. I get my client prepared for it. Most of my clients start with this one, don't know. Start with this, 100 grand, they laugh. 50 grand, they laugh a little less. 25 grand, now they're not laughing so hard. 10 grand, every once in a while from a tax refund, they've received $10,000. And I instruct the client, answer the question the trustee asks. I ask people all the time, do you have a car? And they respond, no. Do you have a driver's license? And they respond, I don't have a car. They half answered my question, half answered another. I tell the client to try to answer the trustee's question to the best of their ability. Sometimes the question is a little vague. So answer the question. Does anyone hold any property that belongs to you? We've already gone over that they can or can't sue anybody. Have you given any property away? Now, if you gave a Christmas gift, you gave something away, but that's not the essence of the question. They're talking about things of value. Sometimes on 341 day, my client will say to me, I just won $2,000 on a scratch-off. And here's how I go over that with my client. Generally, to change a 341 meeting, we need year-changing money. I'll explain. I'd ask my client, if I gave you $5,000 right now, would it change your year, your month, your week, or this weekend? Most of my clients say that $5,000 would change this weekend. So when they had this small amount of money right before, and we're gonna tell the trustee about it, I tell them, listen, it's not gonna affect this case, because we need at least year-changing money. $5,000 is not gonna change this meeting. We're in debt for quite a bit of money here. The trustee's going through their questions. The client, after the first minute, their stress level starts to come down, and this is a very quick meeting, 4 to 5 minutes in general. Another big question for the trustee to ask is, why are you filing now? My clients also think this is the, they're gonna get me moment. I tell my clients outside, we're going to this meeting, into this room. This is the easy answer room. In fact, I can only think of one answer that someone would spontaneously lose their bankruptcy if they said it. I have all the money to pay all my creditors. Keeps piling up. I just don't feel like paying. You'll never have the debtor say this. This is the only answer that's going to lose. When that trustee is asking, why are you filing now? I believe they're asking, really, to find out if the client discloses a financial event that they might be involved in or they might be able to action on. So it's very rare that your client says that, but most of the time it's, I'm being garnished. And the honest answer is the right answer. Have them I tell my clients, we want to be today the least interesting person that ever existed. If you could be forgotten before you hit the door, you've done your job. You want to be an extra in this film, you want to be in the stadium scene of a film, and you want to be so far back that they don't even see your hairline. If you can accomplish that, you've won. Today is not the day to shine. We're having a 341 meeting about our financial life. Years ago, my father, who's a bankruptcy attorney, told me that a lady showed up and had jewelry like a 1980s Mr. T. And if you don't know what that looks like, dripping in gold. It was all fake. That's just not the day to do it. You really want your client to dress quite normally. I wouldn't want them to stand out in any crowd. They literally should be as boring as they come today. That's the motivation. They want to win this meeting. We don't want to be interesting. We want it to be fast. So those are the questions that the trustee is going to ask. You'll notice that I've focused on what the client owns. Dave, you didn't ask the trustee didn't ask one question about debt? As you sit in the meetings, listening to other cases going on, you'll notice that the trustee rarely asks about the debt. Why? You're going to leave that client debt-free. The trustee will very likely say, I am closing this meeting. That's the sentence you wanted to hear. That means that your client has won. Bankruptcies must remain open for 60 days after the 341 date. Sometimes the trustee will say, oh, you're missing 2 weeks of pay statements. I'm going to hold this case open. You don't need to appear debtor until March 15th, which will be a month later, so to speak. And that's also fine. You're going to get the trustee those documents, and assuming that the client didn't make $100 million that week, you're going to win your case. But the trustee is going to say, I'm closing this meeting. That means that this 341 investigation into the client's assets is over. You're going to go outside and you're going to tell that debtor that this meeting is over. We do not have to come back. And previously in this seminar, we have discussed that there's 5 things that happen in a bankruptcy. You meet the attorney, you take the first course, file a petition, have the 341 meeting, which is what we're talking about, and then they take a second course. You remind the client about the second bankruptcy course that they will take online or over the phone. You tell them that they should be doing it promptly, and if they did it ahead of time, that's wonderful. I would suggest to my clients to do it ahead of time, but many times they don't. You're going to remind them. And of course, the 5th part of the bankruptcy is the discharge. So those are the questions that you'd expect to get from a trustee. Let's just say you had a client that had a business in the past. Trustees are going to ask quite a bit about that. But many times you're going to have a client that is not heavy with assets, and there you will go. So when a trustee asks about debts, many times they'll say something like, I see you have student loans here, you know they're not dischargeable. And they're asking about it just to discuss, to make sure that the client has been advised of that. One other question that the trustee might ask about debts in the 341 meeting is, have you done a consolidation of your debts in a certain amount of time? Let's just call it 180 days before the bankruptcy. Mostly because the trustee can undo that transfer and distribute it to creditors. So you may be, if you're new to bankruptcy, you're going to be surprised how little you're going to be asked about your debts. So this would wrap up the section on 341 meetings. Thank you very much.